As we speak. Let me get to the Attorney General, Lynn Fitch. Good morning, ma'am. How are you?
Hey, good morning, Paul. Very good. How are you this morning?
Busy day yesterday, doing fine. Busy day yesterday, and a lot of things going on. I read some of the excerpts from some of the transcripts from yesterday, and again, one of the things that we, the general public, always on the outside try to do is kind of read into this, whether it's the state Supreme Court or the Supreme Court in Washington, and we're all advised never to do that. But what's your thoughts and your analysis on what happened yesterday?
Well, I'll tell you, yesterday was a very defining moment. You had the entire justice panel seated for the argument, excellent arguments, critical legal argument for all Mississippians. So I think that's very key. Certainly, our office, the AGO team did an outstanding job. Justin Matheny was presented our argument. He's the Assistant Solicitor General. Mm-hmm. So very intense, very engaging, again, very important argument yesterday. And you're right, Paul, people have to stop and remember the whole nexus of the arguments yesterday were about the rights of the people of Mississippi to amend their Constitution. And we have to be really focused on that. So arguments for that particular issue, not about medical marijuana, always focusing on what were the rights and what are the rights of Mississippians to amend our Constitution. Very key points all the way through. Again, very involved, very engaged, very lengthy arguments on both sides. But it's significant. It's like you and I were talking about earlier. This case truly, if it goes the other way and the measures are not upheld on these 5 congressional district lines, we could lose the invalidation of voter ID, eminent domain, and a number of other initiatives that have been acted since 2002. So this is significant.
But is that tantamount in any way, or is that just much like, and Justice Don Beam also reiterated this yesterday, this is not about medical marijuana, so therefore wouldn't the judges consider this is not about what happens to the previous initiatives? This is about the constitutionality or the validity of the makeup of the language of the 4 districts as compared to 5 districts.
That's right, and she framed it right off the bat. Justice Beam did that. This is not about the medical marijuana issue. It is to look at the confines of how Mississippians can amend the Constitution, because, this is a process, Paul. If you look at it from beginning to end as the collection of the signatures and so forth, it's about a 2-year process. It includes people that vote all across our state, those including our service members who are overseas. They cast their ballots and so forth. So you have to look at it from a big perspective. And I think that's what the court will focus on, looking at the lines and how it really, from a holistic view, affects Mississippians and our true rights.
Chief Justice Randolph said something on the outset of this. When you read the language, though, where do you go beyond that?
Well, you have to look at the interpretation of the Constitution and the statutes. That you have to read those certainly together. And that's going to be key as well. You just can't look at one; you have to look at the other. And the other side is certainly trying to use semantics. They want to just invalidate the votes based on the semantics. But when in fact those old 5 congressional districts, those lines, they can be used for a number of things. The only thing they cannot be used for is to take members of the United States Congress. And so that's a real distinction that I think the entire justice panel will certainly have to take a hard look, because, and the reality is, we have a number of boards and commissions and different appointments are made and so forth, Paul, and many of those appointments are based on those 5 congressional districts. That's how those board members are aligned. So you have to take all that into consideration as well.
Yeah,
where do you draw the line?
I understand that, but I would submit to you also that if there was that apparent vagueness in this, do you think that the Supreme Court would have held the hearings?
I think it certainly warranted this, the hearing. I think it's key because it is such a critical argument and it is significant for all of us. It did bring to light a number of other issues where the legislature had been apprised of these different situations and chose not to take any action over the last number of years. So I think it shines a light on future changes that might need to occur through the legislative process.
Would you agree that from the Chief Justice and the rest of the court, they all understand the immediacy of this, and there's a monumental task that the health department has to do, and I think that this is going to be done rather quickly?
Absolutely. I would believe that they will come forward fairly quickly with rendering an opinion. And you're exactly right, Paul. The Department of Health has a big task ahead. They are, forging forward with their rules and regulations because, again, by the law and the amendments, they have to do that and have to come forward with these. So they are moving ahead as they should in order to be prepared based on what their charge is set out to be.
Is there, and it's almost a rhetorical question, but is there any representation from the and I guess that would come through your office, nobody from the legislature speaking on this?
No, our argument was certainly representing the Secretary of State and the proper actions. It was brought, if you were watching some of the arguments yesterday, that was some information that was put out there, the number of times the legislature had looked at it or had chosen not to take any action. Those are part of the arguments that were brought forward yesterday and questions by the justices.
The State Attorney General Lynn Fitch. Quickly, let me ask you, because I know you got to go. What's your feel on this? It will happen again today, of course, but what's your feel on here as far as a timetable?
Timetable, I'm not sure. I do expect them to come forward fairly quickly with an opinion because there's so much that has to be done, work ahead, particularly with Department of Health. So we're hoping we'll get some resolution on that because you'll also remember, Paul, that people are in the process right now of moving forward with additional initiatives to go on the ballot. So you have signatures being collected as we speak on a variety of different other topics.
Are you for sure for Friday tomorrow again, or is that just a tentative?
I'm sorry. No, I don't know when we'll get an opinion. I hope it'll be rather quickly. I don't have a date certain, but I think because we do have so many other topics that are percolating through the initiative process, certainly it's important for the Department of Health, and it's just an important resolution because, again, as all Mississippians, we want to know that our rights are protected because we have chosen to amend our Constitution.
Let me go back and ask that again. Do we know if the hearings will continue tomorrow, or is that tentative?
No hearings, to my knowledge. Yesterday were the arguments in front of the full panel.
So what happened?
All of our justices.
Nothing happens today?
No. I mean, arguments were finalized yesterday.
I got you.
And now it's certainly under advisement from all of the justices.
So that's it, and we're waiting for the opinion now.
That's correct.
That's amazing.
Correct.